CLE, so this will be somewhat informal. So please feel free to grab food, drinks throughout. It won't hurt our feelings. We know that you're here to bowl and not ethics CLE necessarily, so we'll get through this as quick as we can. We also know the NFL draft is starting soon, so we'll try to be mindful of that. Please feel free to holler out if it starts while we're still rambling on. But no, we're happy to be here. We're big fans of the ACC and your chapter, and happy to support. Today's topic we hope will be kind of fun. There's already one bowling pun. We hope there's not too many more bowling puns. But this is the marketing and legal 7-10 split, how to not be the no department. And so we're going to talk about just strategies for working with your marketing group, what advertising law really means, and how to really understand that business function and what's our role as lawyers. So with that, I'm Craig Carpenter. I'm the head of our datum practice in Dallas for Baker Hostetler, and that's the digital assets and data management group. And so my practice is primarily based on privacy and technology transactions, which you'll notice I didn't say marketing, but you'll learn in this presentation that technology and privacy are cornerstones of digital marketing these days, so plays a big role in that practice. And with me is my partner, Tamara.
Hi, everyone. I'm handling the less techie part of this presentation, the softer stuff. I'm a business litigator at Baker Hostetler. My involvement in this topic is that I handle cases that involve deceptive advertising practices. I have a general litigation practice, but a lot of my cases involve those issues. Happy to be here with you all today. Craig's going to cover an introduction, and then I'll go through truth in advertising and substantiation issues, which are kind of fun and not always quite clear.
So we say this is how to not be the no department for your marketing and advertising function. But before we can get to how that works, we're going to do a little bit of a background on advertising law. What does that mean? What's involved? I'm sure most, if not all of you, have practiced a good bit of advertising law, maybe without even knowing it. But we're talking about advertising and marketing. So what is advertising? And it's really not just commercials and print ads, cue the Mad Men theme song. It's just anything that your company is trying to put out to its customers, right? Like it's any of those messages that you're putting out to consumers. So obviously it's television, print, radio ads. These days it's a lot of digital. We'll hear about how, as many of you are probably well aware, advertising budgets are really shifting to digital and social these days. But it's also press releases, annual reports, and all these things can count as advertising. And so you really need to pay attention to some of the things we'll talk about, even if it's not sort of the traditional advertising. We'll spend a lot of time talking about digital and technology and privacy, and that's because, again, as hopefully most of you are familiar with, that's where a lot of your businesses are spending ad dollars. Social plays a big role in advertising these days. These stats are kind of mind-blowing to me that like 500 years of YouTube videos are watched every single day on Facebook. Like that's hard to just like fathom in your brain. And a lot of e-commerce is on mobile now too. And you see the statistic here that for the first time recently, most online purchases are occurring on smartphone. And so companies have obviously moved their ad dollars to that space. And so advertising, we're talking about a couple key traditional subjects: IP, privacy, consumer protection, entertainment, and commercial transactions. Obviously as the in-house counsel, you already wear a lot of hats, and so you're familiar with working in all of these areas. And then finally, I'll kind of wrap up our introduction by stating the obvious. If your business does advertising and marketing, you, as sort of the first line of legal defense, are probably doing some aspects of advertising law. So we're going to get into exactly what we mean by that.
So now we'll move into truth in advertising, and this is really the fundamental basis of advertising. It needs to be truthful and not deceptive. The key principles, we've broken it down into 3. Claims must be truthful, accurate, and properly substantiated. And a key to substantiation is you have to substantiate it before the advertising is disseminated. And this applies to both express and implied claims. We all understand express claims pretty easily, but implied claims are where most companies get into trouble because it can be less clear if the claim is deceptive. So that's where you see most of the enforcement actions, most of the cases, most of the litigation is in the implied area. And another thing that tricks people up sometimes is that all reasonable interpretations must be supported. So if it's ambiguous, that is construed against the advertiser. So that's an area that might be less clear to some folks. So one of the key areas where we've seen action and we've seen lots of violations, we see them every day if you're scrolling through Instagram or TikTok or one of these social media platforms, influencers and endorsements. This area has gotten a little bit out of control, and the FTC has seen that, and the FTC is here to try to take control of that situation. This is one of the FTC priorities, is making sure that influencers and endorsements comply with advertising law. And when it comes to endorsements, one of the key things, it seems obvious, but people seem to be forgetting about it, is that an endorsement has to be the honest opinion of the endorser. We're seeing situations where that's not quite what's happening, and it becomes pretty apparent whenever you see a celebrity endorsing so many products. They could not have used that many products. Another key principle is that if there's a material connection between the advertiser and the endorser, that has to be disclosed. If your mom thinks you have the best cell phone in the world, you better let people know it's your mom. And if somebody's getting paid to endorse something, that has to be disclosed as well. That's another key principle. Now, whenever we're looking at things in the endorsement arena, we typically think of consumers, celebrities, and experts. And those have just it's all the same fundamental principles, but each one typically has a different thing that they're doing wrong. So with consumers, when a consumer is an endorser, their testimony, their representations, they have to reflect their actual experience with the product. So within that, they have to have actually used the product. With celebrities, same thing. It has to be their experience, their opinion, and if they state they use the product, they have to use the product. And there's a continuing, this one's a little bit different, there's a continuing advertiser obligation to ensure that the endorsement reflects the celebrity's opinion. If the celebrity loves your product on Wednesday, on Thursday said it gave them a rash and is horrible, you probably want to stop using that Wednesday advertisement and maybe get a different endorser for next time. But that's a little bit of a spin for celebrity. It seems like when I mention these things, it seems obvious, right? But there are actually some really recent enforcement actions that have involved these issues. One of them involves Google and iHeartRadio. And in this area, there were certain radio personalities that were saying that a phone was great, took amazing pictures. There was something about a spotted owl in there. And just these things that clearly indicated that the individuals had used the phone. Big problem, they hadn't. And so the penalty in this case was, I think, about $9 million. And not much to them, but a lot to us. But it was just one of these situations where the FTC says, hey, you're getting out of hand on one of the basic principles. We got to slap somebody's wrist so everybody remembers that this is a fundamental principle and you can't just get around it. We're out there watching.
Question?
I think it was just that the representations were so blatant. And, I don't know the answer for sure in this case, but in the discovery in that case, it was found out that certain people at iHeartRadio were questioning the practice because they were saying, hey, wait a minute, they're not using these phones. They shouldn't be making these statements. Litigator gold, right? And so I don't know how it was found out. I don't know if it was just that the statements were obvious or something else, but I don't know the answer in that situation, but it's either something so obvious or somebody told on somebody.
A lot of times it's because the influencer screwed up. Like there's the famous Scott Disick example where he posted in his Instagram the lead text and it says, Scott, post this at noon tomorrow. And it was included in his thing. So it was like, obviously that's not your opinion because you copy pasted the whole thing from your agent into your Instagram. And so, but that's where on the transactional side, this space has gotten really crazy. So, those of you that work with influencers, 5-6 years ago when this was kind of new, you're working directly with, celebrities and famous people. Now, you're dealing with micro influencers and nano influencers and really, really niche audiences. And even these people that are not celebrities in the traditional sense, they're represented. There's all these management companies for influencers. And so as a transactional lawyer, it's the space has really changed, and you're dealing with a management company that represents a bunch of influencers versus one-on-one. And so the contracts have changed. We used to beat up influencers saying, hey, we own everything you produce, we're the company. And now that they're all represented by agents and managers, it's a little more of a push-pull on that negotiation. So, but to the FTC point, what you'll see in these agreements with influencers a lot is, hey, we're going to attach the FTC endorsement guides to this agreement, and you're going to basically rep that you've read it and you're going to comply with these. And so the FTC does have everyone a little bit spooked in this area.
Now, a little bit, we've already had some audience participation, but now time for a little bit more. We have a few case studies throughout the presentation. I'll read the case study. Here we go. You probably can't read that. So you're in the legal department of online retailer Mucci House. Marketing head FTC Volatier hands you his new marketing campaign proposal, which centers around 2023's #1 influencer. His good friend, Kelly Kardashian, agreed to post Instagram reviews, highlighting that Mucci handbags are 90% more sustainable than competitor Manel's handbags. Somebody sees it. Kardashian will also plug Mucci's new skincare line and state the moisturizer improved her skin texture 85%. The ad campaign also features an actor who will play a dermatologist. The actor will inspect Kardashian's skin with a magnifying glass and confirm 85% improvement. We all have to get this moisturizer. FTC will also add a product review function to the Mucci website, which will state that product reviews reflect the views of all purchasers who submitted reviews. We could spend the whole time on this case study, by the way. But does anybody see an issue with any of these things? Or all of these things? What was that? Oh. All of it? Okay. Anything in particular? Yes, yes. And I caught a reaction about sustainable. Exactly. Right, she better use it. Okay, so I'll try to work through them a little bit faster, but everyone's picking up on them. Sustainability is a hot button issue with the FTC right now. We have been seeing and will continue to see greenwashing issues coming up, or greenwashing enforcement. Back whenever the green guides first came, or last updated, I think it was 2012, there's some research that indicated that consumers viewed sustainable as meaning it lasts a long time. Now the world has changed a lot, and sustainable is the new green word, right? And so there's a lot of guidance that needs to be updated as to sustainability. As to this prompt in particular, what does it mean? We don't know what it means. Correcting this would mean having to kind of explain to the marketing department how we can adjust these certain things. Oh, and I forgot our funny potential responses at the end. So is your response, do I get a free Mucci bag if I rubber stamp this one? This is where ethics come in. We got to get our 0.5 or whatever it is here. This is where we get it. B, not on my watch, Mr. FTC Volatier. Or C, okay, we have some major and minor adjustments to make, but we have something to work with here. So that's the answer, right? Major adjustments being key. So with the sustainable, with the comparison, if you're going to have comparative advertising with a competitor, you've got to be 100% on backing up that claim. And usually you're just getting yourself into more trouble than you need to get yourself in. Certainly not worth it here. It's probably better just to state how the handbag is sustainable, the practices, to highlight the practices within the advertising. And as far as the 85% improvement in skin texture, that's almost impossible to measure. In the arsenal of nightly face creams I have, I think the advertisements state that 85% of users saw whatever improvements or something along those lines, rather than saying one individual had a percentage, and that's what you picked up on. And the other ones that obviously you don't want the actor playing the dermatologist pretending to be a doctor in making statements, especially ones that can't be backed up. And then so the last one about the product review function, it's not bad on its face, but that you have, if you're going to do this sort of thing, you have to be prepared to let the negative reviews be out there, because you cannot delete or hide the negative reviews. And that's really, this one could be workable, but you have to be prepared to get the negative with the positive. So now we'll move into sweepstakes. This one's easier. So generally it's viewed as an illegal lottery if you have prize, chance, and consideration. So we have to eliminate one to have a proper sweepstakes. Obviously you don't want to eliminate the prize, so that's not an option. But you'll need to eliminate either chance or consideration. With chance, you could have a contest instead, or with consideration, you could have an alternative method of entry or just no consideration period. And that's how you stay out of trouble with a sweepstakes. And people are still getting in trouble with sweepstakes. So you had the Dogecoin case, it's fairly recent, but actually the court a plaintiff filed suit, but on this particular issue, the court found that the alternative method of entry, while not on the first page or prominent, it was within the rules of the sweepstakes, so it was okay. There were some other issues in this case, but on that particular one, the court said, hey, there's an alternative method of entry, this one is fine. And you may have gone to a charity event lately, and maybe you didn't win the Gucci purse in the raffle, and you're thinking, I'm gonna go report these guys. But you shouldn't do that. One, because you're not terrible people. And two, because there are state exceptions for charitable organizations. And it's not a blanket exception. There are certain guidelines and rules, but if anyone supports a charity, helps them set up a raffle or anything like that, you may want to have them go reference those guidelines. They're available on the AG website. So we'll move into another case study. So you just landed your dream job as head advertising lawyer for a hotel chain based in Maui. The flagship property, Maui Luau, underwent extensive renovations last year to make it Insta-ready. Flower walls and neon light affirmation art abound. Online sales are lagging, and the marketing team created an online campaign to increase engagement with travel-ready elder millennials. The team plans to raffle off an all-expense-paid 7-night Maui Luau stay for an entry fee of $5 per entrant via Instagram. And I don't really know what age is elder millennial, but I know I'm just barely in Generation X, so y'all can let me know if my age bracket's off on this. So is your response, no problem? Is Instagram like Facebook or that TikTok thing? B, no way, I don't gamble. That's the no department. C, do you prefer $5 or chance? That's how not to be the no department. And it's messing up my double negatives there. But that's how you come to a resolution. Say, we can do this. We just have to eliminate one of these. We could have an alternative method of entry. It's just knowing the rules and adjusting it slightly. It's not a no, it's a yes, we can do that. We just got to change something. Again, there's your ethics credit. So moving into claim substantiation. This one, I think we all get it, so we don't have to spend a lot of time on it. But if you make a claim, express, implied, it has to be substantiated, again, before the advertising is disseminated. All reasonable interpretations, and then also both express and implied. Went over these a little bit just a couple moments ago. Example of an express claim, this is for NASDAQ Board Vantage, 50 plus Fortune 100 clients. We know exactly what they mean. It's very easy to see if this is true or false. So you don't have a whole lot of activity in this express claim area. Implied claims are where we have more activity, and they're a little bit more fun to look at, and it's not always a bright line obvious rule. You have advertising experts who disagree about certain issues. And it's the overall net impression of the ad, and it can be communicated through graphics. If you have an advertisement that has, an X-ray and a, lab coat and that sort of thing, you're indicating that it's something that's scientifically or medically approved or backed. So you have to be careful with those things. The advertiser's intent is irrelevant, completely irrelevant. And again, it's the source of most legal challenges. The exception to all of these things is puffery. But be careful relying on puffery because it often does not carry the day. But here, it's something so hyperbolic or vague that you can't take it seriously, right? And it's an opinion that is incapable of being subjectively proven. And context is everything. I have a couple of examples up here that should be familiar. Dunkin' Donuts, America runs on Dunkin', puffery. BMW, the ultimate driving machine. We may have some aficionados in here saying, no, that's a statement of fact. But it's puffery, or a statement of fact for you. And there's recent activity that it's a diaper case. I won't get into it too much because nobody wants to talk about diapers for too long. But in that case, I think the statement was that more comfortable than yoga pants for your wild child. And the NAD said, okay, no, that's not a claim, that's puffery. So it's a fun one, but we won't talk about that one for too much. So case study, your in-house counsel at WhistleClean, which manufactures steam mops. Your CEO wants to be number one in all things in life and has demanded that advertisements include tagline, number one steam mop brand. Lead independent sales tracker Bilson shows that WhistleClean has sold the most steam mops in the US in 2022. The ad team will include a disclaimer in the ad that states based on Bilson data. Your response: no problem, says your number one counsel. B, no, our mop stinks, it's deceptive. Probably not that one. Surefire way to get fired. C, if you've got the data, you've got the tagline. Anybody? See, look at you, so ethical, so ethical. So this is based on an actual NAD case. And in this case, the NAD said, you know what, it's okay, because by the market data, independent market data shows they are the number one selling. That's how most people would interpret this number one claim. The NAD said it could be a little bit better if you indicated by what the scope is, what the date is, what the year is, that sort of thing. But this is okay enough. We're not going to make you change it, but it could be better if you included some information that said, in 2022, number sold the most units or whatever the case may be. But this was okay. One more case study before we turn it back over to Craig. You are GC of Billow Pillow. You approve all final ad copy. The latest print ad depicts a woman sleeping on a floating mattress with her head resting on the company's number one product, Billow Pillow. The lower right corner indicates a graphic with a seal that states green safety shield. Is your response approved? Or, no way, our pillows are as hard as rocks, that photo is deceptive. C, looks great, but what's green safety shield? My ethical lawyers? Exactly right. This is based on an actual case, and in this situation, the individuals using green safety shield, they made it up, it was their own thing. So they were told, no, you can't do that. And so we should not do that. Back to Craig.
Okay, I'm going to start with the test and then make you guess where we're going with this. Let me know if this example sounds familiar to you. Coachella Weekend 2 is about to start. Frank Ocean has dropped out and Blink-182 is replacing him. Your marketing team knows from social that Mark from Blink-182 is a big fan of your startup bottled water brand. Your marketing team has secured an event space in Palm Springs and wants to do a Coachella party with a social campaign tying your brand to Blink-182, starting with a photo from Mark's Instagram where he happens to be drinking your water brand, and including TikToks and interviews from the party all live. Your team wants to partner with a local guerrilla marketing agency to get your brand's name all over from Palm Springs to Indio. They need a decision on whether they have the green light to start the social campaign and move forward with the experiential marketing like yesterday. Does that sound familiar with anyone that works with marketing teams? So that is not an NAD real example. That is based on my flight. I just came back from LA on Coachella weekend, and this is based on the young woman sitting next to me telling me about the Coachella experience. So that's where that comes from.
If any of you want to be impressed by Craig, let me show you the size of the writing that he's reading. I just tried to hand him my copy, and I just got progressives last week, so I'm very impressed.
Millennial or whatever. Your response is A, Coach Wada, B, absolutely not. I don't have the time or the resources to even begin to understand half the words you just said. Or C, okay, let's get a plan together to clear this, starting with the social campaign. And so as any of you that practice a lot of IP, your ears were probably kind of burning during a lot of that because that's the next topic we're going to discuss. And so here, before we get into it, one more example. Does anyone know this mural? Has anyone seen this mural? Your marketing team is working on shooting the fall 2023 lookbook, digital lookbook. They hired a photographer and found a great mural in Deep Ellum. The Deep Ellum fence is the name for it. And they want to build a campaign around the mural. They plan to use real people they find in Deep Ellum to model the campaign. They also want to highlight the eco-friendly nature of the line and feature comparisons between your products and the competitors' products in the lookbook. They are leaving literally right now to start the photo shoot, and they want to just double check with you to make sure all the legal bases are covered. Does that sound like the marketing group? Yeah, we're leaving right now, but like we're covered, right? So your answer is, why are you asking me? I'm not a photographer. Absolutely not. There's way too many issues with this. Or, okay, let's start and get the releases ready. Have we reviewed the contract from the photographer? And have we contacted the mural artist? Spoiler alert. So as you can tell from those examples, one kind of big cornerstone that we mentioned earlier of advertising law involves IP. So hopefully we have some IP lawyers. This will be very familiar to you. This is a big part of what we do as advertising lawyers. The rules of engagement for IP in advertising. Use of content by advertisers, by businesses, is not the same as individuals, right? That should be pretty familiar to the IP lawyers. Just because normal people on their personal Instagram are going and posting pictures of this mural all the time doesn't mean you as a brand can go do that necessarily. Because anything the brands put out is going to be commercial speech, and so different set of rules. The platform terms don't necessarily give you protection all the time. As we'll talk about with especially TikTok and music is kind of a hot button issue right now. And so be careful. If you retweet or repost something, you can't just assume, oh, because I can do this, it must be like fair game for me to do it. Trademarks is a big part of this, obviously, both sort of offensively and defensively. If your marketing team wants to shoot content, what third-party trademarks are in those ads? Are we making sure that anyone, like we talked about the guerrilla marketing, are we making sure that anyone putting our ad messaging out there is using our trademarks appropriately? And then, as Tamara mentioned a little bit, comparative advertising is a hot button issue and heavily litigated, both because of the substantiation issues, but also trademark issues as well. So, when you're doing comparative advertising, and the reason people do comparative advertising, it works, right? It's really powerful for consumers. So the message is not, don't ever do this, right? We're not the no department. It's that you have to sort of make sure your substantiation is on point because it's going to be reviewed by your competitor. And you also got to be careful with trademark use. So here, these are some of the considerations for comparative advertising, right? Make sure that it's apples to apples comparison. There's plenty of NAD decisions, which for those that don't know, NAD is the National Advertising Division. It's a dispute mechanism self-regulated by the ad industry through the Better Business Bureau. So it's kind of like companies go fight it out in the NAD instead of suing each other, and it's a way to get ads taken down that you don't like. But there's plenty of examples of comparative advertising disputes saying that's not apples to apples. You're comparing your top of the line product to our sort of starting product. And so that's a big issue for comparative advertising. And then generally make comparisons, not just ash canning, right? So not just saying like their product sucks. It's like our product is 3 times better in this way, right? So that's kind of the rules for the comparative advertising. We talked about murals. Those of you that have been to a advertising or IP CLE may know where this is going from the picture. But this picture is from the digital lookbook from American Eagle. It's getting a little dated, but I think it's been in every IP textbook since 2014 when it came out. But this is exactly what happened in this case where you see the picture. American Eagle went and just shot their digital lookbook in front of a mural that was just wide open in Miami. It was public. It was on the street, and they shot their whole digital lookbook, and they were sued by the mural artist because, again, anything they put out is commercial speech, right? It's not just me on my personal Instagram saying I like this artwork. They're turning it into a commercial message, and so obviously this gets us into copyrights. A big thing we'll talk about when we talk about sort of the agreements you deal with in advertising is to make sure you own what you want to own, right? Like the photographer example from the case study. Look at that contract. Like, are we going to own what he produces, or do we just have a license to it? One of the trends right now is a lot of video first and real time. Right? We want to shoot this live. The case study said we're going to be going live from our Coachella party, right? Well, that's hard as the attorneys. How are we going to clear stuff that happens live, right? And so again, we can't say no all the time, but we got to understand and work with the marketing group that maybe someone needs to be on site to kind of see what's happening live to make sure there's proper clearances. But there's lots of challenges there. And the other kind of IP issue you run into a lot is the right of publicity. And this, again, hopefully this case is familiar to some of y'all that practice this. This, again, was getting a little dated. It's 2014, but this is the example that you can't, if you see a picture of a celebrity with your product, that doesn't mean you can go use that, right? Like, this was just a picture of Katherine Heigl walking down the street. She had the product. Brand is like, that's gold. I'm going to post that out everywhere. But again, they're a commercial message, and she did not approve this. She was just walking down the street, and so there was a lawsuit, right of publicity lawsuit in that case. And the risk assessment, because this happens a lot. I've had marketing groups. They say, hey, look, that kind of publicity is like, you can't pay for. That's the top of the line publicity. A celebrity is just using our product in the wild. But obviously there's big risk with that involved, and there's not great defenses to just using, especially a famous person's image, without making sure to clear the publicity. But the flip side of that is if you get the celebrity's permission, again, remember copyrights, that might not be enough. So you have the celebrity's permission, but someone took that picture. Someone has that copyright. So there's double clearance there. There's publicity and copyright. And so that's why we say that IP clearance is sort of a cornerstone of advertising law. Questions?
Is your most likely situation if you were to use the celebrity thing out of permission that they would send a C&D, and so you've already gotten a day of use of that, or are they immediately going to, leverage for damages of some sort?
A lot of times, the photographers and celebrities are moving for damages, right? Because this is their likelihood is their business in a lot of cases. And the interesting thing, you'll see this on the copyright side, celebrities trying to post their own image, right? But it was taken by paparazzi or someone else, and they're getting hit for the copyright claims for that. And so it's a wild world of clearances out there for social. And so again, it's not assuming that we have the rights. It's, okay, let's make sure we have clearances both on the copyright side and the publicity side. Test time. See if you can think where we're headed based on this example. Your marketing team just found an obscure tech startup that promises to provide a huge database of insight into your key demographic. They promise access to user data, including sensitive data on 100 million people. The marketing team plans to dump this data into your CRM and then launch a campaign to collect additional user data from your website by giving out a discount code. Who's guilty of the giving all your data for the 10% off coupon, right? They will send that data to third parties for list enhancement and also potentially license that data out to third parties for additional revenue stream. That's great, right? A new revenue stream, we're going to license out this data. They got the contract from the data vendor, and they need you to review it before close of business. Right? Marketing teams, always got to be done that day. Your response, sure, what could go wrong? Absolutely not. GDPR, right? Everyone just says GDPR and says we can't do it. Or C, okay, let's dive into the contract from the data broker. Do we know where their data set comes from? And then let's cross-reference this proposed campaign for the coupon and for the data collection with our privacy policy on our website. Does our privacy policy allow us to do this? We all know what the correct answer is, and we all obviously know where we're headed next, the world of privacy. which we will not spend too much time on because I'm sure you've all heard many CLEs on privacy and CCPA and the like. But we will talk a little bit about how this touches on advertising, right? And privacy, again, is kind of become a cornerstone of advertising because the more you know your customers, the better your ads, the more stuff you sell. And we'll talk a little bit about ad tech as a big component of this. Ad tech runs on data. That whole ecosystem is because of data. And so your website's probably doing lots of crazy things with analytics and cookies and pixels. And that's not inherently a bad thing. It gives you lots of good insights. But in this world of enhanced privacy regulation, it can be a little bit tricky. So cookies, tags, pixels, SDKs, this is the tech that's probably currently sitting on your website that is helping you build these databases. The trend, as I mentioned, is that there's increased scrutiny and regulation around behavioral and targeted advertising. I'm sure we're all well aware of CCPA and the state laws. We have our sort of token slide on CCPA and privacy laws. But really, like, what's interesting for advertising is, for the first time, the law is really taking a hard look specifically at targeted ads and specifically at cookies and pixels and these technologies. And so, in the past, if clients' websites had, hundreds of pixels and cookies running, and now with the regulation, you're having to look at that, do an audit. Do we even know what half these cookies on our website do? Are they passing data to Google and to Facebook and to these third parties? And so it's the ad tech world is a little, I think, spooked based on what's happening in the data privacy realm of, third-party cookies are sort of going the way of the dinosaurs. Well, where are we going to get our insights, right? If we're trying to run a business, our marketing group is trying to get insights on our key demographics. If we can't use third-party cookies, how are we going to get those insights? What's the replacement strategy? Because again, we're the lawyers. We're trying to protect the company, but marketing, they live and die on those insights, right? And so they really want that. And so the privacy world is a really interesting space right now for advertising lawyers. Oh, and quick shameless plug. Speaking of privacy, I pulled a couple of these. This is Baker Hostetler's DSIR report, Data Security Incident Response. Every year we do a big report with facts and analytics based on all the data breaches we cover. This came out today, so hot off the presses. Don't burn yourself. I put a bunch of them out there. Please feel free to grab them. If you ever need infographics or stats to take to your leadership about why you should invest in privacy and data security, shamelessly cribbed from this. There's copies out there. I can give you additional copies.
We had an emergency spiral binding session today just for you all.
Came out this morning. Yeah, these are the first physical copies produced. Okay, so we talked about the ad tech and cookies, and so again, as the lawyer, it's understanding who are our advertising partners, doing the cookie audit, understanding what's on our website, and really kind of evaluating your data strategy. Test time. I think this is last test.
I think so.
Yeah, last test. Your marketing team wants to engage an ad agency to support creative and media buy. They want you to review the agency agreements of the top contenders. They also want to sell ad inventory on your website to third parties. They ask if you have a template IO and whether they should just use the IAB template for inventory sales. They ask if they should do sales in-house or engage a supply-side platform. They need all this in place by May 1 to launch the big Cinco de Mayo campaign. Your response. Is this like that thing in Mad Men? Absolutely not. We've always handled creative in-house. Okay, let me benchmark the agency agreements against the ANA template. And yes, we can look at doing ad sales, but I will have an amendment to the IAB terms that we'll need to include.
Now, this is an area as a litigator where I can chime in and say, you really want Craig's help on the front end with something like this if you don't handle it in-house, because you don't want to get crossways with your ad agency. And it's rare that companies' ad agencies sue one another, but it can happen. But definitely you just don't want that relationship getting off track. And there are certain provisions that you want to pay close attention to. That's third-party licensing, copyright and trademark clearance, as Craig mentioned, and he'll mention more as he moves along. but he's an expert in this area and can keep you out of a lot of trouble if you need somebody to review these agreements.
So, question, yeah. It is from the National Advertisers Group, courtesy of Reed Smith. Actually, is the firm that wrote it, and it does have maybe a bias, but their approach was to take a middle of the road approach. So that's one of the things we'll talk about. I do think it's a good benchmark, right? And so that's what when I start with clients to we're looking at these ad agency agreements. If you don't have other benchmarks from doing this before, that's a good start, because it is, the big trade group's interpretation of what should be kind of middle of the road. And it's often amended. So, I'll caution, if you're working with sophisticated parties or you are a sophisticated advertiser, it's going to be amended. I've never seen it used verbatim, but I think it is a good starting place and it is a good benchmark. And so, we'll talk about some of those templates, but this is, we all know commercial agreements. You're all very good, obviously, commercial agreements, but advertising has some quirky sort of agreements. And so that's why we put the advertising agreements as kind of one of the cornerstones of this practice. You have ad tech, which we talked a little bit about, the agency agreement, which is obviously a big piece. You also have pieces that are kind of entertainment, because you may be dealing with talent and production. And then you got the social media platforms. And so, I won't go through the whole spiel about ad tech. If you'd like to talk ad tech, we can do this all day. It's a very interesting ecosystem. But I do have some slides in here if you want to kind of learn more about it. Ad tech is really how advertisements get delivered and measured online, right? So any ads you see on websites, ad tech is the technology that's driving that. It's a huge ecosystem. I mean, you'll see here's the slide. There are hundreds of players in between when creative gets delivered to the supply side platform and when an ad appears on a website. And all this is happening in microseconds. But there are so many niche companies that have a piece of the ad tech pie. And these are kind of the big players. I know it's kind of hard to read. It's kind of hard to read on mine too. But you have advertisers, media agencies, demand-side platforms, supply-side platforms, publishers, ad servers, measurement verification, and data suppliers. And again, all this is happening in basic real-time, right? So if you're a company, and like our example, you have some inventory on your website, you say, hey, we want a revenue stream, we're going to let people put ads up there, right? Then you would be sort of on the supply side, and you would say, we have inventory. Someone buy ad space on our website so we can get a revenue stream. That's going to go in the ad tech machine, and companies are going to bid on that space, and ads will appear on your website. So again, something that seems so simple and happens so quickly has a lot of moving parts. Again, here's kind of the ecosystem. The ad goes in one side, goes 100 different directions, and then ad shows up to consumer eyeballs on the other side. Let's talk a little bit about another kind of quirky agreement in the advertising world that's a little bit different than our normal commercial contracts, and that's your agency agreement. And so a lot of companies have advertising in-house, right? We can build our own creative, we can do our own media buy in-house, but others use agencies, and there's lots of agencies out there. There's gigantic global agencies, Publicis, and there's smaller local agencies. But advertising agencies can do your creative. They can help you come up with campaigns, come up with the actual advertisements. Or they could do media buy. They're helping you get the ad out there. Like they're the ones going out, finding the billboards, finding the magazine space, getting you on TV, all those things. Or the same agency could do both. And so, one thing to keep in mind when you're messing with agencies is there's a lot of industry consolidation. And so, if you're not familiar with the agency agreements, they're going to be using a lot of third parties for their services. They may own a lot of those third parties. There's been a ton of industry consolidation in the space, which is something to keep in mind. On the creative side, some of the considerations are things you would think of and things we talked about when we talked about IP. Who's going to own what? Who's responsible for clearing these things? Is the agency? Is it the company? Those are all things to talk to your agency about when you're doing creative. On the media buy side, that's where we talked about the ANA template. Media buy is a little bit of an obscure contract, right? One thing to keep in mind is more often than not, when you engage an agency for media buy, they are your agent. Thinking back to like law school of like what agency means, they're going out and signing contracts on your behalf. So they have agency, and so it's important in that contract to understand the scope. What do they have rights to do? What do they need to report back to you? And making sure that because they're your agent, you have a really kind of direct line of communication with them. Again, just to kind of highlight the different considerations on each side when you're dealing with a creative agency versus a media buy agency. Some of these things are no surprise to you and involved on both sides. Some of them are a little unique, again, because like on the agency, on the media buy side, like they're going out and signing contracts on your behalf. And so who's responsible, if one of the suppliers is not happy with the payment? It's all good things to think about. When you're working on these advertising agreements with your marketing group, it's good to set yourself up for success and figure out who's involved in the team. And then making sure to do any diligence on these agencies, right? Like I said, they're pretty consolidated. So they may be pushing, hey, we're going to go sign this $1 million contract with this data vendor. You may want to understand whether that's their sister company or not, and like what the profit margin is there, and if there's any sort of self-dealing going on. But again, agencies are not inherently bad. Obviously, it's just you need to understand sort of the ins and outs of how they operate. Digital media buy, again, this is another place we kind of talked about the template. So there's two big templates, the cheat code and advertising agreements. On the agency media buy side, there's the A&A template, which is this great document that A&A sponsored with Reed Smith several years ago that's supposed to be the kind of benchmark for your media buy. And then there's, for actual placement of ads, there's the IAB and 4A's terms, which are the standard terms template for, hey, we want to run an ad here. And that's where you heard me talking in the example about the IOs and the IAB terms. A lot of this stuff sort of starts with these templates. And so it's a good, they're online, you can find them, you can look at them. If you're interested, they're a great place to start in this space. And then again, data is super important. Most of the time we're negotiating these agency agreements, we're spending a lot of time on data. Who owns what are the rights to use data? And so again, kind of thinking back to the privacy side, this is advertising because of ad tech and because everything's going digital, you'll spend a lot of time on data ownership and use. Some of the watch outs on these agreements, again, like the agency is going to want to use some of your data, right? They're going to want to aggregate and anonymize it and use it to improve their services. And again, that's not inherently good or bad, but you just need to be aware of what's happening when they're doing that. Working with agencies, again, just some more tips. I know that the draft's starting in 30 minutes, so we'll try to get through this. And then again, ethics components. So we pulled the relevant kind of ethical tips for advertising law, I think, here.
So Craig and I discussed that to ensure ethics are awarded here, we're going to cite
rules, right? That's
rules.
Like how that works.
Yes.
Yeah.
So definitely covered. We got some rules here. Rule 1.01, competent and diligent representation. If you're advising your company on these issues, or if you're over the legal department, you'll want to have a baseline to at least issue spot. It looks like you didn't really need much of our information to know that our case studies had some problems. That's a good thing. That means you at least have the basics down. Deception, we're lawyers, we know what misrepresentations, omissions are. But some of the more detailed things, it helps to have a little bit more of an understanding if you get involved in this kind of work for your company. And then the way that interplays with scope and objections of representation and the advisor role is that you're not there to be the no department. You're there to serve your client, your company. And so you just have to balance those two things. Obviously, always doing the ethical thing and not telling the client or your customer to do something wrong, clearly, but trying to balance what they can do with advertising. I mean, if you don't sell your products, you don't have a company. So you've got to give them a little bit of leeway to do good advertising, but have enough knowledge of the law to keep the company out of trouble. So those are your ethical bounds there. They're somewhat obvious, but we need to cite them so that you all get your ethics credit.
And then finally, just kind of to wrap up with some takeaways, again, because the theme is like, look, we're not the no department. We're here. We're a different business function from marketing. We have an important role. They have an important role. And so just to kind of understand where marketing is coming from, a lot of the case studies are real life examples, right, that I've run into of working with marketing groups. And again, it's like, hey, someone's on site right now shooting photos. We just wanted to make sure it's cool, right? Like it's always working backwards, I feel like. But just kind of understanding their business function. A lot of what they do happens in real time, right? Like if you want to really pick up on new newsworthy events and things like that, they have to move very quickly and work in real time. And so understanding that objective, making sure that you're close to them and they understand your role as well can really go a long way. Learning the lingo, right, of like how they're operating, what they want to do, when they're engaging third parties, all the lingo about influencers and how the influencers fit into all this. Knowing what Coachella is probably a bonus, but kind of understanding their lingo and how they operate. And then I mentioned the timelines, the relevant stakeholders. All right, you may have a privacy function, right, in your company, and so they may have a heavy hand in what's going on in the advertising group. And again, it's not because what the advertising group is trying to do is inherently good or bad. They feast on data, right? Like they want all the data, all the insights they can get. They don't care where it's coming from. They don't care how old it is. And your privacy function, obviously has data minimization on the mind of like, hey, we want to purge stuff that doesn't have key value to us. And so it's kind of working together to identify what we're trying to do. And sometimes it's explaining to the marketing group that, hey, our privacy function could be a differentiator, right? Like that our consumers may want to know how good our privacy function is. And so in exchange for maybe purging some of these data and insights that you guys want to hoard so bad, like we may have a sales pitch here on like how much we respect privacy. And so kind of coming together and understanding each business function's objectives. Don't be afraid to call outside counsel for advertising advice. And again, the theme, don't be the no department. Any questions? Yeah, we see that a lot. And like, if I had $1 for every time I heard from the marketing group, everyone else is doing it, I wouldn't be here right now. Because that is often the excuse is, hey, everyone else is doing it. Well, my answer is, everyone else doesn't necessarily have the same like risk tolerance we do, right? Like everyone has different risk tolerance. We may do things a little bit differently, but that's a common excuse. But you're right. I failed to mention, and I wanted to bring it up. TikTok is a bit of a minefield right now. There's especially on the music side. Just saying, oh, it's out there. Someone else is doing it. We're just gonna, do a piggyback on it. That doesn't absolve you of your responsibilities to those copyright holders. And there's a lawsuit right now. I think it's in Florida for Warner Music is suing Bang Energy Drink for a TikTok. And I think there's a Monster Energy. I don't know why the energy companies get so out of line, but there's a Monster Energy lawsuit too over the music in the TikTok, right? Like they pulled the TikTok, like that's fine. The platform, TikTok, lets you sort of remix other people's videos, but that doesn't always include the music, right? You don't know where the music came from. And so, Warner and I think Sony and some of these other big labels, they're suing companies. Like they've had it. And these are, I wish I had the site. I can find it and give it to anyone that wants it. But this is happening right now. Like these are pretty recent. And so you're right. The TikTok's a bit of a minefield. And so we just have to preach caution. Yeah. Yeah, and that's what a lot of my clients, again, it's like, what is our risk threshold? And so some clients, I'm like, hey, let's see if we can find someone that we have a reasonable claim is like the owner of any copyright or IP in this. And let's send them a DM and try to get permission. And that way, like we at least look like we played nice, right? And we tried to figure this out. Because what you don't want to be is one of those companies that's like, hey, you ripped off this person that created this dance and they're coming from poverty and this was like their way to like be famous, and you brand just ripped them off and didn't even think twice about it. Like that's like the terrible PR. So some of my clients, they have different risk thresholds, but I'll tell them like, hey, at least try to do the right thing. And you may get it wrong, and that doesn't absolve you of liability. But if you could say, hey, we thought this was the owner, we DM'd them, here it is, and we got permission from who we thought was the owner, that won't fix your legal problem because copyright is a strict liability offense, but it can help your PR problem a lot. Yeah, and you know, as outside counsel, we're on both sides of this, right? So I have to tweak my position based on who I'm representing. And so, you know, the ad tech vendors, software vendors, look, they do need sort of some aggregate anonymous data to provide the service, right? And them using it to provide support and to give a better product is, again, not a bad thing. But when I'm on the brand side, again, I usually don't just like, unless, you know, maybe if I'm a health system or something, I'm probably striking it every time. But if I'm just, you know, a CPG brand or whatever, I don't hate that idea that they need some data from me. But what I do hone in on and where I do mark up and redline these things typically is like, I want to know that sort of what your de-identification process is. I want to make sure it's good. I want to make sure not everyone thinks about the personal information aspect of it, right? It won't identify a person, but I want it to not identify a person, but also not identify my company, right? Like, I don't want it to be tied to, you know, leading, you know, energy drink manufacturer, because that's value, right? Like, if they could package that data and sell it, and they don't mention you, they don't say, hey, this is from, you know, Gatorade, but they say this is from a leading energy drink manufacturer, right? That's value. So what I sort of nip around the edges of like, yeah, you can have like usage data maybe, because you probably need that for the system, but it better not identify any people. It better not identify us. And then sometimes I also say, you can't repackage it and sell it as a standalone, right? Like, you can use it internally, improve your product. I get that. That somehow benefits me because if your product's better and I'm using it, great. But don't repackage that, right? Like, don't spin off a data broker business based on what you took from me. And so yeah, I don't think it's bad. I'm not one of those people that's going to say strike it every single time you see it. But I just like spend a little time to be careful and like really make sure, like, okay, you say aggregate, like, what does that mean? Like, I want to make sure this doesn't come back and point to me in any way. Yeah, so yeah, that's a great question. Like, the whole, and this is all the programmatic, right? It's programmatic ad buy, and like, so this is all happening in, like I said, microseconds, and that's why there's so many. It's all digitized, right? And it's all these different tech companies basically talking to each other. So that's why if you're the business, like if you're trying to sell inventory, you can't really do that real-time selling yourself unless you're Google, you know, or one of the big companies. So you engage one of these platforms, right? And they're going to be the ones that help with the bidding and the instant real-time putting that ad up on the side of the app. So yeah, all digital, all runs through the tech ecosystem, where these big players are doing like this literal auction of bidding that's happening in microseconds. Yeah, I think that the current FTC would agree with you. Commissioner Khan and her team are very much big on sort of these tech monopolies, and that claim has been made that you have the sort of Google monopoly, but also, like I said, the demand side and supply side platforms. Like, there's not many companies that do that, like you said, and so it's all part of the big tech, right? That this current FTC administration is really focusing on. Good question.
Does everyone want to go bowl now?
Bowling time? All right. Thank you all. Appreciate it.
Thank you.
Yeah.